Traditionally, cataract surgery involved replacing the lens and then suturing the incision, which often led to postoperative astigmatism. However, Dr. A discovered that by making a precise incision at a specific part of the eye, the lens could be replaced without the need for sutures, significantly reducing complications. Dr. A applied for a patent on this new cataract surgery technique. Later, Dr. B performed the same procedure without permission, and Dr. A filed a lawsuit for patent infringement. Should the court recognize Dr. A's patent rights?
Patents are designed to grant inventors exclusive rights to their inventions for a limited time, in exchange for public disclosure of those inventions. The purpose of granting patents is to encourage innovation. Developing new products or technologies requires enormous time, money, and effort. But once created, these innovations can be easily copied, since they are intangible. If anyone could freely use new technology without compensation, inventors would lose motivation to innovate or share their discoveries. Without patents, society would waste time and resources reinventing technologies. That's why patent law strikes a balance between private rights and public benefit. Inventors are given temporary exclusive rights, and after that period, anyone can use the invention freely. Over time, the scope of patent protection has expanded from industrial inventions to include artistic works, performances, trademarks, trade secrets, and even databases. But how are patents different from property rights? Unlike physical property like houses or cars, patents have an expiration date. For example, 20 years for patents, and 70 years after the author's death for copyrights. Trademarks can be renewed every 10 years, effectively lasting indefinitely. Intellectual property can be divided into industrial property, like patents, designs, and trademarks, and copyright for literary and artistic works. Patents protect technical inventions. Design rights protect product shapes, patterns, and appearances. Trademarks protect names and logos. Utility models protect smaller technical improvements. Copyright protects artistic creations like music, novels, films, and art. Now let's go back to medicine. Doctors often develop innovative surgical or procedural methods in the course of treating patients. The question is, should these medical procedures themselves be eligible for patent protection? Those who argue in favor of patenting medical procedures say, 1. Patents would motivate doctors and institutions to develop new techniques, improving medical quality and patient outcomes. 2. Hospitals and medical institutions would invest more in developing unique medical procedures, which gains competitive advantages and creating new industries. 3. If medical devices and drugs can be patented, excluding medical techniques just because they're acts of care seems inconsistent and discriminatory. Even if medical procedures are patented, it is possible to make balancing interests through regulation. By capping royalty rates or allowing compulsory licensing, ensuring that patients can still access treatments while respecting inventors' rights. However, those who oppose medical procedure patents raise serious concerns. 1. Medical procedures involve human lives and shouldn't be restricted by patents. If a specific surgery is patented, hospitals might be forced to pay excessively high royalties, and patients who can't afford the cost might be denied treatment. 2. Negotiations over patent licenses could delay urgent medical procedures, putting lives at risk. 3. If a patent holder grants exclusive rights to a single hospital, doctors at other hospitals may be unable to provide the best treatment, and patients might die simply because they are in the wrong place. 4. Unlike drugs or medical devices, most new surgical methods are developed by individual doctors at relatively low cost. Thus, the need for strong patent protection is weaker. What does the law say now? In Europe, medical procedures performed on humans such as diagnosis, treatment, or prevention methods are not patentable, because they are not considered industrially applicable. However, medical devices and pharmaceuticals can be patented. In the United States, medical procedures can technically be patented, since there's no explicit legal exclusion. However, patent holders cannot enforce their patents against medical practitioners, effectively limiting the power of such patents. In China, surgeries, treatments, and diagnostic methods on humans and animals are not patentable. But methods that involve collecting or processing information externally like lab tests, tissue analysis, or data processing can be patented. So should innovative surgical techniques be patentable? Should doctors be rewarded with exclusive rights to their groundbreaking methods? Or should access to life-saving care remain unrestricted? Share your thoughts and opinions in the comments.